Hello and welcome to the Legal Edition. I'm your host, Attorney Mary Kay Loyan. Our topic today, defending the indefensible, lawyers backsliding democracy. Our guest is Professor Scott Cummings. He is the Robert Henningsen Professor of Legal Ethics at UCLA Law School. He is a graduate of Harvard Law and teaches and writes about the legal profession, legal ethics, access to justice, and local government law. He is a recipient of the UCLA Distinguished Teaching Award and is the founding faculty director of the UCLA program on legal ethics and the profession. Professor Cummings was selected as the Fulbright Distinguished Chair at the European University Institute and a fellow at the Stanford Center for Advanced Study in the Behavioral Sciences to study the role of lawyers in strengthening the rule of law. He was awarded a 2023 Guggenheim Fellowship to study the role of lawyers in democratic backsliding and is the author of several books and articles. Let's welcome Professor Scott Cummings. Welcome, Professor Cummings.
Thank you for having me. It's a pleasure.
Now, I've been reading through many of your articles, and you have many publications. And I'm with what's going on today in politics and the media, and with lawyers in the world of ethics. How does one navigate all this? Are these lawyers committing wrongdoing? And what is your opinion on what's been going on with the Trump legal team and the continuous litigation?
Well, I mean, there's a lot of complexity to the story. My focus has been primarily on the lawyers who were involved in the 2020 effort to overturn the US presidential election. And I think even there's complexity to the story. There's sort of different lawyers who came in different times. My focus has really been on the lawyers who took things to a new level of attacking kind of basic democratic principles and institutions and crossed legal and ethical lines in doing so. The people who are very well known, like Rudy Giuliani and Sidney Powell, and people who have faced consequences for their action. But there also were a lot of people who are less well known in that particular story that I've been investigating. And so I think it's a complicated movement. There are lawyers who are engaged in legitimate advocacy around conservative legal policy principles, election integrity, and the like. And there are lawyers who are willing to be less ethical and less legal in their advocacy strategies in the service of Trump's agenda.
I know you talk about backsliding. Can you explain that concept for the American people?
Well, the idea of backsliding is that, democracy can go in different directions, and backsliding is the idea of democracy going in the wrong direction. And to measure backsliding, you have to have a definition of what democracy is in the first place. And so there are lots of democracy scholars or democracy think tanks that kind of try to identify some of the core elements or core principles of democracy, and then they actually go about measuring them through various mechanisms. And these are things that are central to well-functioning democracies, like having free and fair and competitive elections, having a judiciary that's independent from politics, having public prosecutors that are independent from politics, having a robust civil society, having a free press, things that really go to the question of not just having people decide and choose their representatives and have those representatives be responsive to their interests, but also I think essentially having checks and balances so that executives, presidents, prime ministers don't gain too much power. And so backsliding kind of measures the erosion or weakening of these elements and has really focused on, what are the kind of rule of law safeguards that protect against unbridled arbitrary exercise of executive power. And so kind of measuring legal and cultural changes that really point democracy down a kind of road of decline has been the focus of backsliding. I'll say that backsliding is a contested idea in the sense that democracy is never kind of has a stable floor. It's constantly fluctuating. No democracy is perfect, and particularly not ours, right? And given our history and current reality. But I think the helpful thing about backsliding is it does spotlight the notion that things can be better or worse. And there are some objective ways to measure things getting worse, and that's what backsliding is about.
So is it an empirical analysis that's done?
Yeah, so there are researchers and research institutes like the VDEM Institute is one of the primary ones, Freedom House, and they collect data from a variety of sources. They have field experts fill out surveys. They do their own primary research in terms of legal changes that affect democratic institutions, and then they kind of put this all together in a in an algorithm and score different elements of democracy, right? The robust civil society, right? Is civil society free to form organizations, protest the government, or are there laws that crack down on civil society organizations? Is there evidence of repression of civil society organizations? Similar with the press, when governments do things to manipulate the judiciary and to capture the judiciary, as is going on in countries like Hungary, maybe right now going on in Mexico, where there was just a big reform to the judiciary's rules that shifted it from appointment system to elections, and many people are concerned about this. So what these backsliding researchers do is they look at those changes both on the books and also the way they're implemented, and then they aggregate them with empirical data, and they formulate sort of scores for these different dimensions, and then they can kind of measure in this empirical way trends. And the VDEM Institute, which is one of the more well-known democracy watcher think tanks, has done this for a couple of decades now, and by their metrics, democracy worldwide is at kind of its lowest level since the kind of post 1989 democratization movement after the fall of the USSR. So, in terms of their measurement strategies, things in the aggregate have been going down, although there's obviously a lot of variation by country.
Now, taking that data that they found, in your opinion, how does the U.S. fare now, and how, in your opinion, would it fare if Project 2025 was to take place?
Well, there's been a lot of variability, as you and the audience knows, over the last 10 years with respect to American democracy, and the Trump era definitely put a dent in America's democracy. And by these objective measures, American democracy declined, backslid during the Trump years for a variety of reasons that we can discuss, and really culminating with January 6th attack on the Capitol and the legal efforts to undermine the election. I mean, this is a signal element of autocratic rule when you take over the election process and undermine its integrity and refuse to abide by the democratic principle of peaceful transition of power. That's one of the, if you're scoring democracy, if you take away fair elections and permit leaders to stay in power despite losing, right? That's a huge negative mark. So the country went down then. I mean, there are other measures that, so there's sort of formal policy and political strategy that factors into the notion of backsliding. There are also issues around political culture, polarization, the role of technology and information. And so even though, American democracy after Trump has sort of restored itself in terms of some of the safeguards of the institutions, these broader political cultural issues, information polarization persist, and attitudes around the legitimacy of government and its institutions have been in significant decline. And these are threats to democracy, because if people don't support the institutions, then they're vulnerable to being manipulated in different ways. So I think the trend line obviously has been downward. It sort of took a sharp downward turn during the Trump first administration, and sort of has kind of gone back up a little bit, but these underlying risk factors are still there. Project 2025, which you mentioned. Go ahead.
Right. If Project 2025 becomes, the rule of law here, do you see us going further down? I mean, how far down can we go?
I mean, absolutely. Project 2025 is a threat to democratic institutions, and it's focused on a key area of checks and balances, which is the administrative state. And Project 2025, in its kind of primary form, that's been, the document that was put out by the Heritage Foundation and its allies, really is focusing on a strategy for kind of dismantling and capturing key areas of the public bureaucracy. And my focus has been primarily on the governmental legal offices that are part of that public bureaucracy, the Department of Justice and White House counsel. And I think, the way I see Project 2025 is really learning the lessons of autocrats who have been successful in other countries in consolidating power and dismantling democratic institutions through ostensibly legal means, which is this idea of autocratic legalism, right? That authoritarian leaders in the contemporary period have figured out ways to kind of find legal loopholes within their constitutional structure and essentially change the rules of the game in such a way that gets rid of these checks and balances on their power and allows them to sustain long-term rule despite kind of countervailing democratic norms without any force, with just kind of changes in the rules of the game and then manipulating those rules over time to stay in power. And the key moves, if you look at these autocratic legal strategies, if you will, really initially focus on taking out the judiciary as a force of independent check on executive power. So capturing the judiciary, packing it with allies of the executive, and then disassembling the independent role of the public bureaucracy, and particularly public prosecutors and lawyers within government, whose job it is not just to execute presidential authority, but to work in the public interest and push back against presidential authority to the extent that it's showing itself to not be consistent with democratic norms. And so you take out the judicial check, you take out the lawyers within the system who are also supposed to put a check in against the president, and then you have a system in which the president's authority expands beyond its constitutional bounds, and then we have a big democratic problem. So I think Project 2025 is basically, and the Heritage Foundation director, is a fan of Viktor Orban. He's said this much in public statements, and so they've been looking carefully at other countries that have engaged successfully in these autocratic legal maneuvers and have documented that in that particular roadmap for governance. And to me, the sort of the things that I focused on that I do find most troubling in terms of this democratic backsliding problem is that it is designed to kick out lawyers in key governmental positions whose job it is to keep the president within constitutional boundaries. And this is, in fact, what saved our democracy in 2020, because I'm sure your audience knows that, at the end of the day, it was really the lawyers, some of whom I don't have a huge amount of respect for overall in terms of the way they performed during the Trump administration. But in the end, at the end of the day, when the question was whether or not Trump was going to subvert the election, they did in fact say no. They threatened to resign, and that threat was one of the key features that stopped the effort to overturn the election from being successful. So,
there were some guardrails. There were some guardrails, and what I'm concerned about is if he gets elected, those guardrails are gone, and it will be a free-for-all. That is what I am very concerned about for this nation. What are your thoughts on that?
Well, I think Project 2025 is about getting rid of those guardrails for sure. So I think it's important to contextualize Project 2025 in relationship to what happened in 2020, where the government lawyers actually did their job and stood up to power. And so the idea of Project 2025 is to put loyalist lawyers in the positions that last time were independent and thwarted the effort to take over the election. And so I think that's a very explicit strategy. I don't think there's any secret behind that. And so, yeah, that would mean that the people who would be in those positions next time around, if they were asked to do the things that, you know, Jeff Rosen and Rod Rosenstein were asked to do last time and said no, or Pat Cipollone in the White House Counsel and said no, they would say yes. And I think that's a very stark way of thinking about it, right? If that scenario were to recur with different people in those key positions, you know, we might be in a very different position.
Mm-hmm. And there's no more Mike Pence to say no either.
Right, and Mike Pence, as we recall, was a trained lawyer, right? And now the trained lawyer who's in the vice presidential spot is someone who's aligned himself with Trump in terms of denying the validity of the results of 2020. And I think it's not just speculation to presume that he was selected precisely because if he were asked to do what Pence was asked, he would expect that he would do it differently.
Exactly.
And that is a very frightening prospect.
Is very, very chilling prospect. What concerns me even more is not only will he do the bidding that is unlawful, he's spreading and peddling lies about his own constituents in the state of Ohio. I find that juxtaposition quite alarming. Here is a man who's supposed to represent as a senator those people in Ohio, and yet he's peddling falsehoods about the very people he's supposed to represent.
Well,
what does that say about ethical character?
Yeah, I mean, yeah, I think the question of ethical character can be seen in both in terms of, you know, J.D. Vance's refusal to say that the election in 2020 was legitimately won by Joe Biden is just a massive Democratic red flag. And you know, Mary, I'm actually from Springfield, Ohio. I grew up in Springfield, Ohio, and can say that it saddens me to see the things that are happening just with the politicization of dynamics there that just shouldn't be involved, and the distortion of fact in ways that do again should trouble everybody in terms of ethical conduct. The insistence that the immigrants who work there lawfully are not there lawfully, and that somehow, even if they were unlawful, it would be fair to treat it with such disrespect is something that you know, shouldn't be countenanced, and hopefully people will deliver the final verdict on this in the election.
I do hope so. Now, Vance himself, he's a Yale trained attorney, so he would be in that elite category of lawyers that you talk about in your writings. So what motivates an elite lawyer, or one who has gone to an elite law school, I should say, from one who has not? In your research, what have you found between the motivations to work on these cases that really have no merit and bring frivolous cases?
Yeah, I mean, this is a huge question. And, you know, sort of getting into the motivations of lawyers who are willing to do things that are clearly unethical, and they're very smart people who you presume know what they're doing is at some level unethical is, something that is fascinating and difficult to parse out at some level because you can't get within people's minds. I mean, I've looked at this by kind of thinking about their trajectories or biographies or backgrounds, sort of what leads them to the positions that they're in and what specifically are they asked to do. And I think there are different stories for different kinds of people. I mean, elite lawyers and people that have started to write about this in the popular press and in some academic settings, but elite lawyers on the right, I mean, the profession is influenced by politics, right? So if you're an elite lawyer, you go to Yale Law School, you go to the University of Chicago, like John Eastman, you have huge amount of opportunities. You clerk on the court, or you have similar kinds of elite opportunities. If you want to be in politics, and the conservative party has been taken over by far right elements and has really shifted power in that direction, you have to make a choice about what you're going to do with your career. And the choice is to stay in the mainstream and resist and maybe not participate, or to go in and see where that takes you. I think obviously people like J.D. Vance, John Eastman, other legal elites that have aligned themselves with Trump have gone in and believe that they can kind of pursue their political and professional agendas in a way that benefits from that relationship without having that relationship take them down. And maybe they believe that they can also shape what Trump does in ways that might mitigate some of the worst consequences. I'm not sure about that. But they've clearly made a deliberate choice to kind of support in exchange for some career benefits. And I think this would be predicted, right? If politics moves that far out, you're going to have to decide, are you going to go all in, or are you going to stay outside of it? And we've seen the mainstream conservative lawyers and politicians who have tried to resist. I mean, they don't have a role, right? And Project 2025 is essentially to make sure that they do not have a role in the next administration.
Well, these lawyers filed 60 frivolous lawsuits about the 2020 election, and they were frivolous, or they were not based on fact, and they were basically, kicked out of court. So are there going to be any repercussions for this type of behavior where they invent things that aren't true? I mean, there are rules that say you can't bring a false case before a court or a tribunal. So is the bar going to step in your opinion? Is something going to be done? I mean, you have the Rudy Giuliani's, you have Eastman, you have Chesbrough, you have Powell, Sidney Powell, Jenna Ellis. What's going to happen to these people? They've brought so many false claims forward.
Well, first, I would say that if you look at the roughly 60 lawsuits that were brought after the election and before January 6th, my take on these is that kind of estimating here, the first week of the lawsuits, which is maybe 10, 15 lawsuits, roughly speaking, those lawsuits were not making claims of voter fraud. They were not based on false allegations. They made aggressive arguments. A lot of them were arguments made under state law about kind of technical legal changes that were made by the Secretary of States or the legislatures, given the fact that it was COVID and it kind of made it easier to vote by mail, and restricted poll watching because COVID was in effect and people didn't want to get too close. And so a lot of these early suits were actually brought by legit election lawyers in the conservative legal movement. A guy named Ron Hicks, and that was in Pennsylvania, brought some in the Pennsylvania cases. He's a serious lawyer, and he actually dropped out of the case in Pennsylvania once the court made it clear that they were going to lose, and Trump and the team started to push voter fraud claims. So just to differentiate that there were different kinds of lawsuits, and some of the lawsuits, were aggressive but legitimate. Some of them are pushing independent state legislator theory, which now has been deemed not a thing by the Supreme Court, but at the time was still something that was working through. So there was some legitimate claims. I think, when the mainstream election lawyer experts kind of dropped out after about a week or 10 days, and we had the elite strike force press conference with Giuliani and Sidney Powell and others, and then they really kind of took over some of the cases, and then there were other cases that were brought by people in the battleground states that started to bring these unsubstantiated claims of voter machine manipulation and other kinds of fraud. Then that's when things kind of went off the rails. And I think that the two kinds of cases are connected in the sense that the groundwork was already laid for people to kind of make claims that the election lacked integrity. And so once these kind of legitimate lawsuits went under, everyone was already primed to kind of think that there were legitimate problems in the election, and that allowed these less scrupulous lawyers, unscrupulous lawyers in some situations, like Sidney Powell and Rudy Giuliani, to kind of gain control and take things in the wrong direction. So you ask about what consequences, if any, might be imposed on those lawyers. And if we look at the bar discipline process and investigations and prosecutions against these key lawyers, Sidney Powell, Rudy Giuliani, John Eastman, Jeffrey Clark, who was in the Department of Justice and tried to circumvent leadership to endorse election fraud on behalf of the Department of Justice, Lynn Wood, and some other, Jenna Ellis, and some other less well-known players at the state level, like Alex Culloden, who was a lawyer in Arizona who brought one of these bogus cases around voting machine error and Sharpies being used, and was actually disciplined by the bar, but then he won state election because Trump endorsed him. So you have people at different levels playing different kinds of roles. I think overall, I would say that the disciplinary system has actually worked quite well, with one exception, which we can talk about, which is Sidney Powell. And this exception may go to the problems that we have in a country where bar discipline is meted out at the state level, and so state bars and state processes can be politically captured or politically influenced, at least. But I think overall, with that exception, the system has actually worked well to impose consequences for the lawyers that were involved in 2020. I mean, it has taken a long time, and it's 2024, and we're just seeing Giuliani being disbarred just last week in DC after being disbarred earlier this year in New York. We've seen in August, Jeffrey Clark receive a 2-year suspension, a proposed suspension that has to go up and be validated by the court in DC. And we've seen John Eastman this year, after a very lengthy trial at the State Bar Court in California, receive a proposed disbarment. So the key architects are receiving serious sanctions. And so I think from that point of view, the process has worked, and the process works through, due process. So it does take a while for this to work its way through the system.
But even though these people may be disbarred or suspended, couldn't they still work in a Trump administration in some other capacity other than a lawyer?
They could work for Trump in a capacity other than a lawyer, no question, but they couldn't work as lawyers. And this is important because in order for Trump to do some of the things that he's promised, he's going to need lawyers, right? He's going to need lawyers to prosecute his political enemies. He's going to need lawyers to sign off on executive actions that our constitutional system doesn't allow, like mass deportation of immigrants without due process. He's going to need lawyers to give him the green light in order to do these kinds of things. And so he'll need some of them in the Department of Justice and in his White House that are licensed. And I think this is where, the questions and conflicts about bar regulation are going to come to the fore, because we now have these decisions by bar courts that say, if you're a lawyer representing the president or the president's campaign, you can't bring cases based on false claims. And I think very importantly in these cases, they also say that you cannot rely in good faith on information that you glean from dubious third-party sources like websites or affidavits by political operatives. If a reasonable lawyer would investigate this information and easily find that it's false. This is really important because a big defense of the lawyers in these cases and a defense of the lawyers going forward is going to be that they have information that demonstrates bad conduct that justifies their action. And what the bars are doing is really saying, we need to see that. You actually have to have some objective evidence. You just can't rely on check.
Mm-hmm.
So what this means going forward is just that, lawyers are going to have to realize that they can't prosecute people based on conspiracies. And if they do, they could be held account by the bar and lose their license in the same way that these other lawyers have already lost their licenses. And the bar could actually suspend them temporarily if they're engaged in real-time conduct that threatens the public interest. And this is a very important tool that the bar has to stop things in real time.
But on the same note, we see that investigations into Supreme Court Justice Clarence Thomas have not really moved far along in it's almost 2 years. So, with all this in the backdrop, how can we be assured that anything will really come of any of these other actors, and perhaps, seeing nothing happened over with the Supreme Court Justice, maybe these people could get reinstated in a 2025 agenda. What are your thoughts on that?
Well, I think nothing is certain. So you're absolutely right about that. I think that the Supreme Court is kind of a different beast in the sense that it doesn't have enforceable ethics rules, and there's no oversight because of their Article 3 constitutional authority, which is its own very, very significant problem. Of course, I think it's absolutely the case that the lawyers who are leading the movement to kind of take over key positions in government with loyalists and move an agenda that is either facially illegal or constitutionally unacceptable. I think they understand that they have constraints on their action based on their ethical obligations to a bar. And to be clear, to work in Washington, D.C. As a lawyer in government, you have to be a member in good standing of some bar in the United States if you're representing the government. A lot of them are members of the D.C. bar, but even if they're not, they have to be members of some bar. And so there is a professional accountability. Now, I've looked at these recent cases of Eastman and Giuliani and Clark, and they are making arguments in their own defense, and these cases are going up on appeal that essentially would exempt federal government lawyers. They're seeking to advance arguments which, to be clear, are unprecedented, very, very radical arguments that have never had any traction, and some of them have never even been made within the system of professional regulation. But they are making these arguments, I think, clearly designed to kind of tee them up for appeal on the hope that maybe the Supreme Court would entertain them. And these arguments essentially would deregulate government lawyers from any professional accountability. They're arguments that would say if you serve the government and you serve the president, then you have kind of federal protection against any state or, in the case of DC, district regulatory oversight. And that would be a very, very radical change in our traditions of professional independence. And it would basically unleash lawyers from any constraint, right? Because there aren't any constraints based on the kind of constitutional rules and regulatory rules within the Department of Justice, for example. And now if there aren't any professional constraints, then bringing cases against political enemies without grounds, how are we going to stop that? That's a much more difficult question.
They would, in essence, become legal enablers of tyranny.
I mean, it would be the checks on their conduct would not be there. And I'll say that the other piece that's important to fold in, I think, is the Supreme Court's presidential immunity decision, because in Clark's case, for example, Clark is arguing in his DC ethics case, which he's now appealing, that presidential immunity law actually protects him from bar discipline. So not just criminal liability, but actually the bar, in his argument, can't regulate him or discipline him for actions undertaken in connection with presidential advice. So the immunity decision actually is being mobilized in these disciplinary cases, and the immunity decision makes it very clear that if a president uses Department of Justice lawyers to conduct actions that would be within the scope of his authority, those actions are immune, irrespective of his intent, which could be criminal in nature. And so if he says, I want to prosecute Joe Biden because I don't like him and I want to get back at him, and he instructs his Department of Justice lawyers to do that under the presidential immunity decision, as I read it, Trump could launder that illegal action through the Justice Department, and he would have no criminal consequences flowing from it. The lawyers now are also suggesting that they would be immune under the presidential immunity decision, and they're also suggesting that would block the bar from disciplining them. So then it's a very dangerous situation where you don't have any checks.
Absolutely, that's a recipe for authoritarian rule. Absolutely. Do you have any last words or anything you want to say about the fake electors schemes, the participants, or anything that we haven't discussed?
Well, I mean, there's lots to discuss. I think one thing I would emphasize is that, just in terms of the positive aspects of bar regulation and discipline, I think generally people focus a lot on the litigation and the fact that you have obligations to courts where you can't lie to courts. You have to, bring claims that are based on reasonable evidence. You can't bring frivolous lawsuits. You can't engage in dishonest conduct generally, but lying to a court is a particularly bad thing to do. I think all these things are tend to be the focus of the story about lawyers. I think the important thing to know is, or to emphasize, is that John Eastman and Jeffrey Clark have been sanctioned not for litigation, right? They've been sanctioned in Eastman's case for writing a memo, which is something that most lawyers do a lot of, and the idea that you can get disbarred for writing a memo, and in addition he participated in some of the cases, and obviously he made statements on January.
What was that memo?
He wrote two memos, but they basically served the same purpose, which was to argue that the vice president had constitutional authority to not count the legitimate electors in favor of Biden, and essentially permit Trump to stay in power, despite the fact that by all objective accounts he lost the election. And one basis for the state bar court's discipline of Eastman was that he did write this memo, and the memo was predicated on known falsehoods or reckless falsehoods about the election being stolen as a predicate for the legal advice that he was giving. And also the fact that he used those false predicates to give really distorted legal advice, which he knew or should have known was based on improper use of earlier legal precedents. And so I think that's really important, because we're not just talking about litigation activity getting lawyers in trouble, but we're talking about if you give legal advice based on recklessly or knowingly false claims that are designed to destabilize long settled constitutional principles or democratic institutions, you can be sanctioned. This is important because, as we see in the Jeffrey Clark case, it also applies directly to government lawyers, right? Jeffrey Clark's case was also a case where he got sanctioned because he made he drafted a letter that the bar found contained knowingly or recklessly false statements about the election being stolen that was a predicate for supporting Eastman's plan to validate the fake electors. And so these two things taken together, I think, are really important because it does spotlight lawyers in government to the extent that they're engaged in background legal analysis and advice. That advice and analysis has to be predicated on good information, right? Legitimate facts and not conspiracies, and has to be oriented toward independent legal advice that really looks at the case from an objective standpoint. And you just cannot green light proposals that fail that standard. And that's really important to keep in mind because it's not just bringing cases against political enemies. It's also about drafting legal opinions, authorizing really, dramatic and in some respects unconstitutional changes to our legal system.
Basically, drafting memos based on reality and truth.
Yeah, and objective legal analysis is a requirement of what lawyers have to do in these situations.
Right. Well, I can only hope that our democracy prevails and that and the rule of law. It's a very troubling time, but I'm grateful for people like yourselves to help enlighten the public. Thank you so much for joining us today.
Thank you for having me.
I want to thank our guest, Professor Scott Cummings, for sharing his insights and opinions on legal ethics and its trajectory in our current political climate. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guest, visit us online at thelegaledition.com. As always, this information is for general educational purposes. It is not to be construed as legal or personal advice. So please consult a qualified practitioner as to your own legal or personal needs. And don't forget, subscribe online. Find us on Facebook, YouTube, Instagram, and Twitter, now X, and subscribe to our publication on Substack.